talking.
You may be seated.
Bring the jury.
The jurors are all present, Your Honor.
Thank you. You may continue.
Okay, Mr. Frederick, let's move on to Chapter 2, if we could, and just give us a brief description of what's in this portion.
Chapter 2 picks up exactly where Chapter 1 left off, and this is the communication between Officer Slager and Mr. Scott in the vehicle.
Okay.
And this goes to the point just before Mr. Scott runs from the vehicle.
Okay.
It's all thing we're talking. You like to take the church card? What's that? Okay, let's start with your license. Reason for the stop is your third brake light's out.
Oh, okay.
Okay.
I don't have to do it because, like I said, I just walked across my neighbor, and I was trying to give her that money. He still has insurance rating on the car.
Good. You have insurance on the car?
No, I don't have insurance.
Okay. Well, if you don't have insurance on your car, if you bought it, you have insurance.
Right, yes, I'm saying I'm about to do that Monday.
Oh, you bought it?
To drive the car.
Oh, okay.
Yeah, so my car is down. So you can work the car.
Night, stolen vehicle occurred overnight, 2426 Woodstock Avenue,
So you don't have any paperwork in the
2426
glove box?
Woodstock from
No registration in
Speedway.
there, no insurance?
The female complainant requested to meet in
Okay.
person.
But you're buying this car?
Yes, sir.
Did you already buy it?
No, not yet. I'm about to buy it Monday.
It's a minute ago you told me that you bought it.
Well-
And you're changing everything over on Monday.
And I'm sorry about that. They're going to, I'm about to do everything over Monday.
Oh, okay. All right, I'll be right back with you. Haven't seen the car.
And that video ended at 09:36:10:07, and it started at 09:34:03:12. The last two numbers here are frame numbers.
Okay, and would you explain how the rest of the chapters are divided up?
The rest of the chapters are divided into events that are critical to the understanding of the actions. So the next chapter is basically the chase to the first taser deployment. The next one is the second taser deployment, then the third, then the fourth, then the fifth, then the sixth taser deployment, and the shots fired.
Okay, and there is no animation in this presentation, correct?
No, this is strictly the original video and the associated audio.
So what video will the jury be seeing once the foot chase starts?
The audio and the video come from the same source, the L3 in-car video system. That's the visualization that we're leaving up until we get to the sixth taser deployment, which is the one captured by the Santana video, and we see the Santana video.
Okay, let's go ahead with this next chapter.
Chapter 3, it's the chase to the first taser. It starts at 0, 9, 36, 10, and 11 frames.
Two 23 dispatch 10 Indianapolis, down Craig Street, black male, green shirt, blue pants.
Okay, was there a depiction of the taser on that?
There wasn't. Let me just... One second. Just has to wake up. We took the break, and my hard drive decided to go to sleep, so I'm just going to wake it up. I have to reboot this. Take a moment.
While we're rebooting, if you don't mind, unless your attention is diverted, let's not waste the jury's time. If we can talk a little bit about the chapters that we're going to see by taser deployment. The last chapter in this contains the Santana video, correct?
Correct.
And is it Santana video that you have stabilized, or is it going to be the Santana video as original?
Stabilized.
Stabilized. But you do have a copy of the Santana video as original?
I do.
And you can play that frame by frame if necessary?
Yes.
And in that presentation, can you compute different times based on the frames?
Yes.
And if we needed a time, do you have to count frames, or do you have a method of computing the time without having to count the frames?
I can compute it immediately.
Okay. Is there benefit to a jury member in watching the raw Santana video and comparing it to stabilized Santana video?
The stabilized version is really intended to assist you to see what none of us can really appreciate in the raw video because of the motion. So my recommendation is to rely on the stabilized version to understand what's happening, but if there's any issue as to where it came from, what its lineage is, we could look at the Santana video itself, the original. I have one second, please.
And Mr. Fredericks, is this an equipment problem you're having? Or
No,
is it
no, I have to make sure we're not publishing something we're not supposed to publish, so I have to just remove some words.
Would it be helpful for you to you produce those items to me, correct?
I did.
And those are the items you put on the thumb drive, correct?
Yes.
And those are the same items that you produced to me and that we have produced to the solicitor, is that correct?
Correct.
So, and that is the item that you're seeking right now?
No, I've got it. I've got it already. It's just, I just wanted to make sure I didn't run afoul of a ruling, so it just took.
All right, I appreciate that.
I'm playing it, I had things set up a little bit differently, but because of the limitations, I just had to change things up a little bit, but I think I'm ready to go.
And it is the same thing that you provided to me and I provided the solicitor?
It is.
Okay, thank you.
Yes. So I can play that now.
Okay, and why don't we go back to the chapter with the taser? That is from the chase on.
Chapter 3, yes. Thank you.
Let's publish that.
Two 23 dispatch 10 Indianapolis, down Craig Street, black male, green shirt, blue pants.
Sorry. Yeah. Can we just not publish for a second? I'm going to, thank you.
Do you need a few moments, Mr. Fredericks?
I'll let you know in a second. Yeah, if I would, what I did is to conform to an order, I removed some transcript, which removed one of the taser graphics. So I would need a moment to place it back on without placing the words on.
Can you provide the videos that you provided to me in another format? Judge, to be respectful to the jury's time, I'm very sorry, but could we have 10 minutes? I want to make sure that we can get through this and not have to have the technical glitch again.
Take another break. Please do not discuss the case. Mr. McKinnon, what are you trying to do?
Your Honor, the video chapters that we produced to the solicitor, I just want to make sure that that is what we are presenting here, and I think it is, but we created two versions, one that had transcripted chirons on there and one that didn't. And there is evidently an issue in identifying the correct one because we don't want to run afoul of the court's order. We produced both copies.
To run afoul of which order?
This court's ruling that the jury could not see the chiron transcript.
The court ordered the jury could not be provided copies of transcripts, which is what I explained to you, your interpretation or explanation of what is a transcript and my view of what a transcript is. Which order?
This court's ruling that the jury could not see the chiron transcript.
The court ordered the jury could not be provided copies of transcripts, which is what I explained to you, your interpretation or explanation of what is a transcript and my view of what a transcript is. Apparently they're different things.
Yes, Your Honor. My understanding of your ruling was that we were not to provide our interpretation of the speech as the solicitor's demonstration had their interpretation of the speech. And
Without objection. Ours was without objection. We object.
we objected to the entire thing.
Not on
So-
that basis.
On several bases, not limited to that.
You wanted to provide your transcripts. The solicitor said you had not provided it to her. My interpretation of the transcript is a written document given to the jury to follow one's interpretation. I'm not seeking to allow the solicitor to do one thing and you to not do the same thing. So.
proceeding.
Ms. Wilson.
Thank you, Your Honor. Just briefly, let me interpret the words of the record. I believe all of us were under the understanding that your position was, even though we've been using different words, power runs and transcripts, that interpretations of what is on an item, a video, audio, whatever, interpretations of that are not to be shared with the jury unless they're agreed upon on both sides. And so the presentation that we presented yesterday, which the defense has had for weeks, if not a month, had words at the top, chirons, a new word to me. Nobody ever objected to that. We made great efforts reaching out, trying to get the defense, do you have a problem with our chirons, even though we didn't know that word? Do you have a problem with our language? Is there any problem with it? We got no response. Then, night before last, we get from them, in violation of your order to provide us information that their experts are going to use, that they plan to use in their case in chief, in violation of that order, we finally get produced their version. And it is completely unfair for at this juncture the jury to be shown that. We haven't had any objection to the underlying enhanced audio because that was provided to us in time for us to take a listen. The words in the interpretation has only been recently provided to us, and we strenuously object to this witness now being allowed to show that to the jury. And we thought you had ruled that way, and I think the defense thought you had ruled that way, and now they're a bit confused.
Judge, the audio person that we had an audio expert. The audio expert identified phrases to us. After the defense presentation, we shared those phrases with the defense. The defense objects to the phrases that we have in our audio.
What phrases?
We had I'm not going to call it a transcript. Our audio person wrote down what he thought the words were as Mr. Williams did, and when
What words did he write down?
The words spoken by Mr. Officer Slager and Mr. Scott and dispatch, if it's unclear, the underlying audio tapes.
And that was shared with the state when?
It was shared with the state 2 nights ago after the state's presentation.
The presentation they've had for weeks.
Judge, they've had the tapes for weeks. They've had the ability to have an audio expert themselves, and as a matter of fact, Mr. Williams enhanced their audio. Or testified that he enhanced their audio.
The issue is interpretation. We're not objecting to the underlying audio that they had. They had an expert. He did a nice job of enhancement. But it is extremely suggestible as to what you hear. I mean, we've lived it for 18 months. If somebody comes in the room and suggests that they heard this, then by God, for the next 2 days, that's all you can hear. And if somebody else comes in 3 days later and says, wait a minute, I've listened to this and I think it says that. You listen to it and there you go. And that's the problem with their putting this up before the jury, especially since we just received it in violation of your order. I don't have a, they can argue it, Mr. Savage or Mr. McCune in closing argument can argue, listen to this, you hear this, and if they want to argue it, that's one thing. But having an expert put it before the jury is quite another, when it's objective to.
And Your Honor, their expert put it out before the jury.
No objection.
We objected to the entire presentation.
The origin of this problem goes back to the defense's demonstrated defiance in open court of the court's order to provide reciprocal discovery to the state pursuant to Rule 5 of the Rules of criminal procedure or the South Carolina criminal rules. And it comes again at this moment in time based on what appears to be late disclosure. Admittedly, the rules regarding what the state must provide and what the defense must provide is not the same in many respects. But the court ordered, in this case, that reciprocal discovery be provided. Similarly, with regard to animations and the like, the case law attest is whether the opposing party has had notice of whatever is being offered to the court, even as demonstrative. The court has allowed Mr. Williams's rendition as demonstrative evidence, his view of things, and it's not in evidence at this time as far as the exhibits offered by the state. I have no clue as to what is being offered to the jury because of the defense's failure to comply with the court's order in Rule 5. So what am I to do?
Judge, one of the things that we're supposed to supply under Rule 5 is items that we plan on using in our case in chief. We don't know what our case in chief is going to be until the state's case concludes. So as soon as the state played what they were going to play, we provided what our interpretation was, and I don't think that's in violation of the order. If we had to disclose everything that every expert did when we don't plan on including case in chief, and we might not, we are in the position of revealing a lot of strategy and underlying research that may or may not be used in trial. And we expose ourselves. This is not civil discovery, as Your Honor has noted before, but we have to provide things that are going to be used in our case in chief. And when we know they're going to be used in our case in chief, we have to provide it. The state used their exhibit. They had their transcript on their exhibit. We didn't know until the state played that and until the jury saw that would be permitted. And at that point, we gave them our information, Judge, and I don't think that is in violation of the court's order.
Well, if you didn't know, this witness wouldn't have the need to take all this time with editing from the witness stand.
Your Honor, if I may, we provided to them both transcripted and non-transcripted versions of this well earlier than the solicitor indicates.
Well, back to my original question, what is it? What discrepancy? What new words? What different words? What is it that you're trying to elicit from this witness? I have no clue because nothing has been provided to the court. The solicitor provided a copy of their disc and information to the court. Thus, in the hours that we spent with Mr. Williams on Monday testing the reliability and the admissibility of what he proposed was valuable time spent, as it turns out. Now you want to perform all this for the first time in front of the jury, I guess.
Your Honor, may I approach?
Yes, sir.
This was provided as the differences in the in the expert's interpretation of the words.
So the essence of it all is if you want to have this witness say that he hears on the an audio voice of Mr. Scott cursing the police. That's the gist of, that's why you all have this controversy.
No, and then there's a final issue at the end where there is an unintelligible statement from the.
Oh, let go of my taser. I'll have to shoot you. That's heard somewhere on Santana's video.
That's correct.
And the question is not whether the jury can hear that for themselves, but this witness wants to testify that that's on that video that he can hear.
This witness will testify. This was the information that was provided by the audio expert, was provided to the solicitor. The solicitor has had it, and the audio expert was here yesterday and was subject to cross-examination by the solicitor. There was no cross-examination.
And you didn't ask that audio expert whether or not that's what he heard. You want to ask this witness whether that's what the audio expert heard.
Your Honor, this...
I'm just trying to understand
Yes, Your
why
Honor.
we're out here with this.
This witness used the audio expert's information. That's just another piece like dispatch recordings or any other recordings he had to plug in his timeline. He's not testifying to anything other than what is in evidence in the enhanced recordings.
I see. Well, fortunately, we have rules that help guide us to make decisions. And this one, it raises the question of whether this witness can testify to hearsay or produce hearsay testimony in court. Hearsay testimony being testimony of this audio expert that we didn't hear, that not sworn testimony, but an out-of-court assertion by the audio expert as to, or in a private conversation or otherwise, to this witness. And so you want to have this witness produce that hearsay to the jury. The hearsay of the audio expert by typing it on a screen somewhere.
Your Honor, that is the type of information that experts normally rely upon to produce this. We don't have the dispatch people here, so that's not hearsay. We have, the underlying material, he is just...
Well, the interpretation is the hearsay. That's what we're talking about, not the fact that an audio exists.
We are objecting to the audio.
Anything else?
Your Honor, I believe that the expert testified yesterday as to what was on there. The solicitor had the transcripts in her hand and knew what words were on there. The solicitor chose not to cross-examine, and I believe it's in evidence and it ought to be heard or seen. But not go back to the jury.
You believe what's in evidence?
That the audio interpretation of the audio person.
Oh, that's what you're trying to get in evidence now. It's not in evidence. That's why we're having this conversation, isn't it?
Well, Your Honor, I would once again say that this is the sort of thing that experts normally rely upon for their compilation.
Ms. Wilson, what'd you like to say about it?
You know, again, Your Honor, I think that Mr. McCune is wrong, and I don't doubt his intentions. But the expert yesterday never testified as to the language that you see on this chart that we got last night. He never said those words. He introduced his audio. We didn't cross him because he's qualified, and he enhanced it, and the jury can interpret it however they please. The defense can argue it to the jury however they please. The court ordered not only that the defense and the state provide each other with their expert information, we of course are compelled to under the rules. You ordered that the defense provide it to you, and you still don't have it. And you nailed it when you said open defiance. This is not prejudicial to the defendant. This is not prejudicial to the defendant. They have the audio in evidence. They can argue it all they want. But this sort of last minute situation puts us at odds when they've had what we propose the language to be. This passed at the end of last week. Mr. McCune told me I would be getting over the weekend this information. I never got it until night before last.
No, the issue is whether this witness can offer inadmissible hearsay to this jury. It boils down to that.
That's right.
We're dealing with hearsay testimony in that it wasn't presented by an expert that the defense had. Now, the defense argues that this is information reasonably relied upon by experts. Under Rule 703, an expert may rely upon inadmissible evidence if the trial judge examines the reliability of the inadmissible evidence and excludes opinions not deserving of reliance in specific instances in which the reliability hasn't been tested.
And I think you hit the nail on the head when you talk about transcripts or pylons, whatever. Interpretations of language are so dangerous because they're not reliable when they're in dispute, and these are in dispute. You've heard the Santana video. You've heard the enhancement yesterday. We all heard it with headphones on. And I believe that today is the first time you've realized that that's what's claimed to be said. That goes to reliability. And that's why we believe you should keep it out.
All right, Mr. Savage. We'll let you take over from Mr. McCune if you want to, though one person only is supposed to argue a matter.
I want to address the issue of compliance.
Yes, sir.
Your Honor, you must be referring back to October 21st.
When the court ordered reciprocal discovery to be provided. Yes, sir.
And it's our understanding of the rules that we would provide the state, as we have, with the reports of those experts that we intended to rely on in our case in chief. We would provide the court as well as the solicitor with some 55 different experts that have been consulted with in this case. We're not calling all of them. And we never intended to call any of them. We intended to call a select few. And that information has been provided to the court and to the solicitor. But we are in a position where we analyze the state's evidence, and it only becomes evidence when the court allows it to be evidence. And it is with that regard that this information, which is not new information, which has been in the possession of the solicitor for quite some time, a decision wasn't made to utilize that evidence until 2 days ago when we heard Mr. Williams, who we never thought would be qualified by this court as an expert. And to the shock of the defense, when Mr. Williams was qualified, that's when it became an issue. And solicitor's been well aware of our concern about Mr. Williams' qualifications, his interpretation, errors that he made that you, the jury, have seen, the fact that he could be a 702 witness came as a shock and surprise to us. And that's why the issue of this interpretation came about. But the interpretation is key. It shows the animus of Mr. Scott at the time of the fight.
Whose interpretation is key?
Well, Mr. Williams would agree that the expert.
Well, we're through with Mr. Williams.
No, but Mr. Williams would also agree, the state's witness, that the expletive was used in that report.
Well, no one asked Mr. Williams anything about that.
Well, I have. And that's
When?
what he would say.
Oh, wow, okay.
So this is of no surprise to the state, as they're alleging. Their own expert would say that the expletive was used. The interesting thing is, too, that our interpretation of the audio with respect to what is alleged eye on the ground, we believe is actually Mr. Scott saying eye on the ground. So it cuts both ways. It's not that that we're just trying to get in Mr. Scott's bag. But the custody that the court's referenced, as well as the final warning, is critical to the defense.
All right, we're beyond the discovery issues and all that. We have a witness on the witness stand, and this witness will not be allowed to testify nor publish inadmissible hearsay to the jury. That's the ruling of the court. Yes, sir. You ready for the jury?
Yes, sir.
All right. Let's see, what time? 12:18. All right. We'll get easy. That's long as well. Yes, I told you I made that request. Thank you.
Okay, Mr. Grant, when we last left off, we were at chapter 3. And I would invite the jurors to put their headsets on if they're so inclined. Okay, let's look at chapter 3 again, and once again, this is the chase through the first taser.
Correct, starting at 9:36, 10, 11.
Two 23 dispatch, 10 anything else?
And while we're working on those audio difficulties, why don't we just proceed through that chapter again, and if we have to come back and catch up on some audio, we will.
So I'll start playing from the same time period, 9:36, 10, 11, and it will end at the end of chapter 3.
Two 23 dispatch, 10 anything else? Split down Craig Street, black male, green shirt, blue pants.
Okay, let's just back it up a little bit so that the jury understands the display on this timeline of the taser deployment. So back it up 10 seconds maybe, and
Yeah, it went back to the beginning. I'll just take it to it. So I'm back about 8, 9 seconds.
okay.
Play forward.
Yes. And that indication of taser deployment was calculated from the taser data provided to you?
Calculated, partly validated by the taser data, but also by the audio. We can hear the clicking sounds of the taser. So there's 2 validations.
Okay, let's move on to the next chapter.
Chapter 4, second taser deployment, and 19 frames.
Okay, and once again, there's one taser deployment in that?
That's correct. Taser deployment starts. at 09:36, 45, and 10 frames.
Okay, that's a short chapter. Let's play that one again. Okay, I think our audio system is not operating, so let's go ahead and go to Chapter 4 then.
Chapter 5 is next.
Pardon me, Chapter 5.
And Chapter 5 starts at 9:36, 50, and 17 seconds.
Okay.
And this is the third taser deployment.
Okay? Okay, I think our audio system is not operating, so let's go ahead and go to Chapter 4 then.
Chapter 5 is next.
Pardon me, Chapter 5.
And Chapter 5 starts at 9:36, 50, and 17 seconds.
Okay.
And this is the third taser deployment.
Okay? All right, and next chapter, please.
Next chapter is Chapter 6. It's the fourth taser deployment. It starts at 09:36, 56, and 16 frames.
What we got now?
Okay, and the next chapter, please. And what is this one?
This is Chapter 7. It's the fifth taser deployment. It starts at 09:37, 07, and 18.
Turn right down Craig Street. I own the grove. Turn right down yellow driveway to the pawn shop.
And what's the next chapter?
Next chapter is Chapter 8, the sixth taser deployment, and the shot. Starts at 09:37, 36, and 10 frames.
Dispatch, shots fired. Subject is down. You grab my taser.
Dispatch copy 223, shots fired. He grabs your taser. Subject is down at 9:38.
And once again, to clarify for the jury, is that the stabilized video that you provided there on the Santana portion?
For the point of the shots, yes.
Okay. And could we go back there and let's take a little bit of a look at what you have been able to discern from the portion of the Santana video that is not as clear as perhaps other portions of it. And so this is the last taser deployment here?
Yes.
And is this taser deployment heard on the audio for the Santana video?
Yes.
And is that the way you used to align this taser?
No. The taser was aligned with a combination of the taser report, the taser sounds from the body-worn video. The Santana report was aligned to the broadcasts by Officer Slager and the shots fired to the speaking clock. Then the taser uses the taser report and all its timing was placed on top of this, and it happened to align with the Santana video. So once all the alignments were done and the taser usages were put down on the video, they lined up with all of the audio from both taser and the broadcast.
Okay, can we step through this portion of stabilized video and see if we can discern any of the action on the ground previous to this that we saw a little bit of the FBI enhanced video. I don't believe you were here for that testimony, but there are certain frames that were taken out of this part of the Santana video that would indicate that there was some sort of ground fight. Are you aware of that?
Yes.
And can you step us through frame by frame and let us know when you can detect items that you can interpret?
Well, this isn't the stabilized version of the ground fight.
Right.
Since we're going frame by frame, probably don't need to stabilize it. We just look at the raw video.
Okay.
At 9:37:43:04, we can see obviously we know there's two individuals there because as we get closer we see the two individuals. We've got a little bit of green visible, which is consistent with Mr. Scott's shirt, and then dark area just to the right side of it. Can't really say what that is. And then we have some more information that we can't really define from this position. So we really have two individuals who are in this area. As we move forward, this is Mr. Scott with his green shirt. Legs are up in the air to the right. So that would mean that the other mass would be Officer Slager to the left. We see a rotation of Mr. Scott here in a moment as we get closer, where Mr. Scott's legs come in. And at 9:37:44:09.
Your Honor, I'm going to object to this witness testifying to what is on video. Once again, same thing with the audio, that's the determination for the jury. I don't care if we play step by step, but his interpretation is not something that is the subject of expert testimony. The jury can make their own determination of what is in the evidence.
Your Honor, he's done a forensic analysis of the video, and his trained eye can determine objects that we may not be able to determine. He's not going to give his opinion on anything, I don't believe, that it's not scientifically based, where he is interpreting objects that he sees, and he's not trying to give a spin or any testimony on this. He's observing through his expert eye what he sees, who is where, what objects are where. He has a trained eye. That's what he does for a living. I don't think it invades the province of the jury. They can take his suggestions or leave them.
I don't really object.
So the examination that I'm offering here is considering the technical errors in the video, the predictive nature of motion vectors, considering all of that when I'm providing this evidence. And I'll be very cautious not to provide something that is not founded.
Thank you.
As I move through the images, there's a side kind of lateral movement on the ground, and we can tell because we do have color information. Color information is hard to interpret, so we have to be cautious about it because of the color of the background. And I took careful consideration to note when we can confidently say that the color green, for instance, is not the grass in the background, that the white that we're seeing is actually consistent with the running shoes and not the color of someone's skin. So as I'm moving through from 9:37, 44, 20, we can see some white that is part of the running shoe that's worn by Mr. Scott. I'm going to move forward until the camera comes back up. And then what's happened here is at 9:37, 45, 16, the white of the running shoe that I had tracked for a moment that was on the right-hand side is now moved toward the left-hand side of the image. Mr. Scott is on his right side. This is pointing now to the area of his lower body. I'm going to point up from where the green shirt and the dark part of his pants are, and I'm pointing up to his left arm, which is about at the position. You can see a dark area on the other side, which is another mass, another body, which would be Officer Slager. So the arm would be around the upper body of Officer Slager. The next image, I'll just mention for a moment that we have a lot of blur in the image. This is called motion blur. This cannot be corrected. It's because the camera was moving very fast and blurred the image. It's not because the objects are moving necessarily, it's the camera itself that's moving, and that's a telltale sign of motion blur when we have the blur at an angle and it's throughout the image. To the next image at 9:37, 45, 18, again we have motion blur in the area. There's nothing reliable that anyone really could say about this, and so I'm not going to offer any observations about body parts or anything like that. I'll move forward again to the next image at 19 frames, and then at 20 frames, so 9:37, 45, 20. Again, we have Mr. Scott's back on his right side. We've only gone about 4/30ths of a second, so this is a very, very short period of time. They haven't moved very much. We can see the second mass, which would be Officer Slager. They're pretty much on the ground together in contact. Moving forward through the images. At 9:37, 45, and 26, Mr. Scott's legs are up in the air and his feet are extended above the ground some distance, which I have not measured. So I'm not going to offer an opinion as to the height of his feet, but the jury can look at this image and define for themselves. I'll move forward. At 9:37, 46, 07, we have motion blur by the camera. We have white in two different areas, and from this image, it wouldn't be safe to interpret that these are his running shoes or tennis shoes, either of them, because we'll see in a moment that there's a white shirt underneath his green shirt that becomes visible. So I won't offer an opinion as to what those are, the shirt or the shoes, through the images. As we move forward, the camera is changing its orientation, and so I've done some correction so we have a horizon. It helps a little bit. At image 93750 and 4 frames, we have some motion blur in the image, but we also have, this is camera blur, motion blur because of the movement of the object. So what we're seeing is this is the white shirt that's underneath Mr. Scott's green shirt, and he is in motion. From this image, we can't tell whether the motion is going downward or upward, but his body is in motion. The next image, where we can see that the two masses, bodies are together. The white that we're seeing at the center is from the shirt, underneath the green shirt. I'll move forward. So the camera operator, Mr. Santana, moved his camera to view to the right of the events. So in the stabilized version that will assist us in tracking the information more clearly, the left-hand side of the camera view is cut off here because that's the camera view, that's the left-hand side. As Mr. Santana brings the camera to the left, pans it to the left, to then pick up the activity again, it will appear on the left-hand side of the image and begin to move into the frame. That's an explanation as to why we have this big black border here as part of the process of trying to recover all the data. So as the camera moves to the left at 9:37, 15, and 11 frames, we begin to pick up Mr. Scott on the left and Officer Slager on the right. And as we move forward, I think I'll move forward to an image that's more clear and then back up so we have a bit of continuity of where the objects are. So I've gone to 09:37, 53, 15, where Officer Slager's left hand is contacted with Mr. Scott's right wrist forearm area. And I'm going to go, and Mr. Scott is bent over. I'm going to go backwards now. I'm going backwards one image, so this white area is the shirt, the white shirt underneath the green shirt worn by Mr. Scott. We'll go back again. We have some motion blur based on the camera movement and the movement of the individuals. And then I'll go back again. And so I'm now back to 9:37, 53, 12. And we can see just how difficult it is at that image to perceive very much. But because we've now gone forward, we have some reference now for where the bodies are. So I'll go forward to 9:37, 53, 15, and allow the jury to make the observations they require.
If this enters into evidence, will the jury be able to step through this as you're stepping through it?
Yes. So using QuickTime, you'll be able to use the left and right arrow keys on the keyboard to move through the images. And it's probably best to go to the View key, which I'm presenting here, drop-down menu, and say Fit to Screen. The larger the television monitor, the more with these television monitors, specifically the one in front of the jury is a very good monitor. That would be helpful. If it's a small computer monitor, it'd be hard for many people to look over it. If you have a large monitor like that, the best place to see it is no further away than about 3 times the height of the monitor. So if that monitor is 40 inches high, don't be more than about 120 inches away from it.
Okay, we can continue to move forward.
So moving forward from 9:37, 53, 15, the lighter object, his elbow is up in the air, and his hand would be down toward where his gun would be in his holster. As we move forward, we get motion blur again, where the arm appears to become very distorted, but we can see that that's just a blurring motion. We can see the same issues with the officer's head. And I'm moving forward to 937-53-19, and for reference, I'm going to go forward and point out a moving object, and then we'll come back to this point. So I'm pointing down behind Officer Slager. There's a dark object that is also a motion blur, and I'm going to track that object through a number of images. And I'm tracking it with my mouse. And it comes to a rest at 9:37:54 and 25 frames. I'll back it up a bit to 9:37:54:11. It's a fairly clear image. That image shows very clearly the taser. It's upside down, the handle's pointing upwards, and the pointed end is pointing to the right, and it's in motion. So what I'll do is, if it's okay, is I'll back it up, and we can track the movement of the taser. The last time that I can see pixels that represent the motion of that object that we tracked is at 9:37:53:16. This video doesn't provide us with any other detail as to where it came from prior to this image. All of the other motion blur can be identified to its source because of the colors of the pixel, what we call tonal value. It shares the same tonal value as the officer's uniform reliably. So, but I'll go back. To where we were, and then I'll go forward again to what we see now, ignoring the movement of the right hand at 9:37:53:15 is at his holster area. I'll go forward. At 9:37:53:24, his right arm is still visible behind his back, so it's still in that upper cocked position where his elbow would be bent. I'll go forward. And then at 9:37:53:28, this morning, a witness for North Charlton Police who showed the duty belt demonstrated that it was a double action holster to remove the weapon. And I've examined this holster, and the process of the double action removal is consistent with what we see with the officer's arm. I'll go forward. And we see this is the, and then we see the wires. These are wires from the taser that are coming down from, they're wrapped around the officer's hand. Can't tell what hand they're wrapped around. They come down in front of his body on his left-hand side and also extend from his hand. The wires move toward, they're obviously connected with Mr. Scott as well. So the wires are connecting both of them.
Okay. Based upon your observations of this video, were you able to come up with a time to the first shot from when the people were in contact?
Yes.
And just so we keep it consistent, can you identify the what was called T0 in the Williams display upon which he computed time?
My understanding that he was computing time from his 0 point is at contact or release of contact?
He had a 0 point that was, it's depicted in the 7th slide there in the compressed version of the 7th slide that he had, or the 7th shot. And if you can't match it up, that's fine.
No, well, I think what we've got for a match is when he's at this point, I
Yes.
believe. So yes, I can do this. It's 1.5 seconds.
About 1.5 seconds.
Yes.
Fortune teller. And once again, if the court has admitted some foundational videos into the record already, Santana video, for example. Will the QuickTime player play any of these formats? Do you know? Would the jury be able to use a QuickTime player in the manner using the forward and rear arrows to step through any video that can be played in a QuickTime format?
Yes.
And once again, would your recommendation be that these images, if the jury is choosing to view them, be viewed on a larger TV than a smaller computer monitor?
It all depends on the distance. So comfortably, if the jury is a large group of people, I would recommend something, large like this. I'm pointing to the jury, its current monitor that's being used by the jury. And again, no further than 120 inches would be adequate. I'm using my laptop with a 17-inch monitor. I'm close enough that I can perceive all of the information. I should also note that the last answer that I provided, I was asked how long. Should be very cautious if we're dealing with milliseconds. This image that I counted as the shot being fired is actually after the shot was fired. The gases have come out of the gun. The shot's fired actually between this image and the previous image. But this is the closest time. So if you're looking at when was the shot fired, if you move through the image frame by frame, as we've discussed, you will be able to see the gases come out of the gun. You can see the smoke in front of the gun in most of the shots. That will assist the jury.
Okay, and at this time, Your Honor, the defense would like to introduce defense exhibits 48, 49, 53, and 54.
Sorry, is that 51?
I think it's, let me take a look at these.
Yes, Your Honor, all of them.
As to which ones?
Well, that would be 48, 49, which have been introduced for identification purposes, as well as 54. These are all taken from the demonstrative evidence, and which is contained on state's exhibit. What you got right there? The flash drive.
Now, this is,
That's what I'm talking about. 53, which is demonstrative evidence as well. And we have no opposition to it being shown to the jury, but we don't think it's admissible in the evidence registered.
Mark, for identification purposes at this time, unless there's something you publish it.
and Your Honor, just to clarify the record, I believe I gave you the wrong exhibit number for one of these. The larger of these is actually 51, not 54. No, and Mr. Frederick, please answer any questions that the state may have.
It'll take 20 minutes for lunch.
Your Honor, I forgot you were leaving to, let's just go, let's just press on.
Well, we'll
I thought we had all that.
we'll still take 15 minutes.